The Georgia Supreme Court has heard an appeal on a high-profile murder case. Travis Graham was 20 years old when he shot and killed an 18-year-old who was in his yard after a party in 2020. WALB News 10's Brittany Blake explains how the Stand Your Ground law was used as a grounds for an appeal.
Travis Graham Jr. was sentenced to life plus 5 years in January 2023. Graham was found guilty of felony murder, aggravated assault, and possession of a firearm. This sentence came after 30 people showed up to his home after a 4th of July party in 2020, which started a fight that police say Graham was involved in. 18-year-old Jeffrey Franklin was shot and killed that night. At the time of trial, Graham's mother, Fallon Harris, says she believes her son's attorney was ineffective, which is why they asked for an appeal in January 2025. Harris hired Brian Steele, who was lead counsel in the state's longest criminal trial involving rapper Jeffrey Young Thug Williams.
Mr. Steele has brought everything to light to say, hey, this is what has not been done. This is unfair to this young man, and we need to stand for justice, and he needs a fair trial or even a dismissal because he's innocent.
In Wednesday's hearing, Steele argued that evidence shows Graham was trying to prevent trespass of his property, which is defense of property other than habitation. Stand Your Ground law in Georgia allows the use of force to protect property and to stop a threat. Steele argues that Section 16323 of Georgia Code would allow justification of use of force in defense of property after Graham attempted to keep the trespassers from coming inside of the home or near the property. But the state argues that evidence shows it was only a fight that did not have to escalate to aggravated assault.
You don't need a serious violent felony for 16323 to apply. All you need is a forcible felony. It doesn't say a violent felony. It says a forcible felony. They're on his yard and they're attempting to commit a forcible felony. That's all that has to be done. He can kill.
This argument introduces the issues found in Graham's previous trial of whether self-defense was strong enough and what led counsel to choose that based on evidence.
To your earlier point, there's conflicting evidence since the jury gets to make those decisions, but what we're trying to figure out is what is the effect of trial counsel having not secured that instruction, and would that have made a difference under these circumstances?
Again, I don't believe it would have made a difference because he does have the ability to defend himself and defend others that were at his residence.
Yeah, but then you have to prove that you weren't the initial aggressor. You have all the other sorts of things that come with defense of self and others, whereas this just means if I had a belief that they were attacking a dwelling or if they were attacking, coming on for criminal trespass, and I think that someone was about to commit a violent felony, whether or not I started it or not, I don't have to deal with that.
That is true. Yes, sir.
The state Supreme Court can make a ruling 1 to 5 months after oral arguments. Brittany Blake, WALB, your hometown news source.